On September 19th, President Trump signed a proclamation restricting the entry of certain H-1B workers into the United States unless the Form I-129 H-1B petition was accompanied by a $100,000 fee from the employer. The restriction is effective as of September 21 and will expire in 12 months, absent an extension from the Trump administration. Tech giants like Microsoft, Amazon, and JP Morgan immediately advised their H-1B workers to remain in the U.S. until further guidelines are provided by the administration. But the impact of the proclamation, titled Restriction on Entry of Certain Non-Immigrant Workers, is not as dire as many news media reports and social media posts initially reported. To reduce panic, White House Press Secretary posted on X on September 20th, "This is not an annual fee, but a one-time fee that applies only to the petition." She added, "Those who already hold H-1B visas and are currently outside of the country right now will not be charged $100,000 to re-enter." She further wrote, "This applies only to new visas, not renewals, and not current visa holders." The White House has since clarified that the fee is required for new H-1B petitions submitted after Sunday, September 20th, not just those in the 2026 H-1B annual lottery. Hello and welcome to The Legal Immigrant. My name is Diane Williams and I'm a U.S. immigration attorney at Diane Williams Law. If you have an approved petition, I can help you overcome a visa refusal with a motion to reconsider or waiver of inadmissibility. A USCIS memorandum dated September 20th confirms Proclamation applies prospectively to new H-1B petitions filed on September 21 or later. This includes future H-1B cap petitions or petitions requesting consular processing. The memorandum clarifies that it does not apply to applicants who are the beneficiaries of pending H-1B petitions that were filed prior to September 21, 2025, are the beneficiaries of currently approved H-1B petitions, or already have valid, unexpired H-1B visas. The U.S. Customs and Border Protection issued guidance stating the presidential proclamation does not restrict the entry of current H-1B visa holders. H-1B employees with valid Form I-797 approval notices and H-1B visas may travel as normal and will not be subject to the fee requirements to re-enter the United States. Why did the Trump administration impose the $100,000 fee? The administration says the H-1B program was created to bring temporary workers into the United States to perform additive, high-skill functions, but it has been used to replace rather than supplement American workers with lower-paid, lower-skilled labor. They note the H-1B program largely displaces U.S. workers and suppresses wages because foreign nationals are more willing to work for lower pay. The proclamation states that information technology, IT firms in particular, have abused the H-1B program, which harms American workers in computer-related fields. On average, the share of IT workers in the H-1B program grew from 32% in fiscal year 2003 to an average of over 65% in the last 5 fiscal years. The proclamation notes that abuse of the H-1B program is a national security threat. H-1B-reliant outsourcing companies have been found to engage in visa fraud, conspiracy to launder money, conspiracy under the RICO Act, and other illegal activities to recruit foreign workers to the U.S. H-1B workers must have at least a bachelor's degree in the relevant field of study to fill a position in a specialty occupation requiring certain knowledge, skills, and educational credentials. But the H-1B employer is not required to recruit U.S. workers unless it is found to be H-1B dependent or a previous willful violator of H-1B requirements. According to the White House, the restrictions will curb abuse of the H-1B program while allowing employers to hire the best of the best H-1B workers. It is not clear how the change will be implemented or whether it will be subject to legal challenges in federal courts. In the meantime, employers and foreign national workers may consider other visa options such as the O1, L1, or TN. To request a consultation on a visa refusal or inadmissibility finding, you may contact me via email at info@dianewilliamslaw.com. This content is general information only. It is based on current U.S. immigration laws, regulations, policies, and guidelines which are subject to change. Do not consider it as legal advice for any individual case or situation. The sharing or receipt of this information does not create an attorney-client relationship.